12:05 in the afternoon here on 90.3 FM. It's Wednesday. That means it's time for Helping Seniors of Brevard. I'm John Harper, and of course, Kerry Fink is with me here as we have a special panel of guests this afternoon. Kerry, to introduce to everyone, how are you today?
I am doing good, John, and here we are. We're in the thick of the holiday season, and we're all doing well and safe, and that's good, and we're wearing our masks and taking all the precautions that the CDC is talking to us about so that we can enjoy this holiday season. I'm going to introduce my panelists, and then I'm going to talk a little bit, give you a quick update on Joe. We have a really interesting topic today. It's titled The Frustrations of Probate Administration. You know, John, as we get towards the end of the year, everybody always starts doing kind of a look back, you know, what we accomplished this year. Did we get the stuff done that we wanted to do? And of course, this year, I'm sure whatever planning we had made for this year is almost tossed out the window.
Right.
The year in review, yeah.
But we tend to do that as we get towards December. We try to figure out where we were and then where we're going in 2021. So I'm so excited to announce that we have from the law office of Amy B. Van Fossen. Amy has been a great friend of Helping Seniors for quite a while, and really is one of those folks in the community who has led the way helping, particularly she's known for helping veterans access benefits and things like that, and just an expert at all things elder law. And so today from her firm, we have Katie Jackson Stolz. And welcome, Katie. How are you today?
Good. Thank you for having me.
And another great expert in the field of reverse mortgages, a really long-time friend of the Helping Seniors organization. You go way back on all this, is Barb McIntyre. Welcome back to the radio.
Well,
how are you?
thanks very much. I'm great. Glad to be here.
And so how are you guys doing this holiday season?
I'm doing wonderful. Just thanking my lucky stars, staying healthy, and plugging away.
That's the battle. And how about yourself, Katie?
Also doing well. The year's gone by quick, but I'm looking forward to a little holiday break.
I can totally get it. John, how about you? You for yourself? You've been busy keeping the radio show going all this time through all of this too.
Well, it still has been a very busy year, despite all of the COVID going on. Sometimes I wonder how we get everything done, and then the added situation with having to deal with the virus and kind of planning all of your moves. At least I do, as far
right.
as where I'm going, how I'm going, do I need to go, and things like that. And I kind of judge a lot of that on how much mileage I put on my car. And normally I do, in the past, I do about 500 miles a week. Mm-hmm. And up until this morning, when I got in the car this morning to come down to the studios, I had about 35 miles on the car.
Mm-hmm.
Saving a little bit on your gas budget then, I guess. Well, you know, I was just talking to somebody else actually yesterday how we have become very inventive and creative about using technology. I know you guys from the legal standpoint, I remember early on that talking with some of the folks, Greg Schwendeman, for example, in your office, we did a number of Helping Seniors updates where we were talking about how you guys, because of what you do, you're considered an essential business, and you had to find ways to keep working through this entire pandemic.
Absolutely. We did. We had to improvise and make sure that our clients still had access to the legal services they needed.
Yeah, and I remember talking with you, Barb, the very same thing. You had to get very creative because just because we have to, give 30 days. Well, that was a long time ago. 30 days to stop the spread.
Yeah, boy.
but we still had to get creative in a way that we could keep things moving forward. And I guess that's one of the things we're really going to talk about today in this topic is because some things don't wait, and I guess that's one of the reasons why the things that you guys do from an elder law perspective are so important, because just things keep happening and life keeps happening, and then you got to keep things moving. So I wanted to ask you first, really for those of us, and I consider myself the layperson. You guys were in here talking shop just before the microphones go. I said you're already over my head. I mean, but just for simple sake, what is probate? And let's just start by laying that groundwork so everybody can gain from this conversation.
So probate is the court-monitored process where we gather the assets of the person who's passed away. We see what creditors are out there, pay any that need to be paid, and then at the end we distribute those assets to the rightful beneficiaries pursuant to the will, and if there's not a will, pursuant to the law.
Right. Now, I know you guys are experts because there's a whole library, by the way, of radio programs and things, television programs, and a lot of different material along the way that is available to you, listener, at helpingseniorsofbrevard.org, helpingseniorsofbrevard.org. Or if you like YouTube, they're all on the Helping Seniors of Brevard YouTube channel. And if you like Facebook, you can find them all on the Helping Seniors of Brevard Facebook page. And I know, for example, with Amy, there's been a number of programs where we actually talked about, because it sounds like that's a large part of what you guys do in the law office, is ideally you're helping people set their assets up in a way that it streamlines that whole process. Am I saying that the right way?
Absolutely. So I think what you're referring to is estate planning. So we do have a lot of individuals who want to plan for the inevitable when they will pass away. So they want to avoid probate through estate planning, and that's actually an area that our firm has really picked up this year due to COVID. A lot of people, really got it into gear to finally come in and do their estate plan with the fear of, maybe catching COVID. So our estate plan department has been incredibly busy due to the COVID virus this year.
Yeah, and so as we talk about some of the things, when we always see this in Hollywood movies, right? This is like the average person's exposure to this, the reading of the will and all of that. Mm-hmm. But walk us a little bit through that whole process. Like, when do you guys get involved? Somebody comes to you and says, well, this is what, so-and-so has just passed away and now we don't know what to do. And is that a place that you guys often find yourselves getting involved?
Absolutely. So everybody grieves differently when the loved one passes away. So some people will call us the same day that mom or dad passed away.
Wow.
Other people, they just wait a few weeks. But nonetheless, they usually come to us and then we identify what assets their loved one had, and we see how they were titled. So that's a big important thing, is how the assets were titled. If they were joint with other people, then those other people probably have access to the money now. Mm-hmm. But if someone passes away and the assets were titled in their name only and they didn't have a beneficiary designation or a transfer on death designation, then those assets are going to need to be probated. Mm-hmm. So we really look at those assets as well as the death certificate. We see if there's a will. We read all those terms, and then we have to petition the court to open the probate process. So that's a big misconception. Even though, I may name my husband as my personal representative in my will, the bank or whoever is going to want documents from the court that really authenticate that I am that person. Mm-hmm. So we work to get those documents from the judge so that person can use them to access what they need.
Okay. Now, since we titled this, and I guess I understand enough that I've understood that a lot of states call it like an executor, but here in Florida we call it the personal representative. Am I saying it right, that it's basically one and the same? It's just the terms that we use here, the person that is in charge with making sure those I guess all those affairs are taken care of, right?
Absolutely. So up north they use executor and executrix, but they're synonymous with personal representative here in Florida.
So when we get into this thing about frustrations of probate administration, I can imagine one frustration would be probably if you don't have access to all the data that you need even to help figure out what's going on. But there must be much more to it than all of that.
There can be a lot of frustrations of probate on our side as the attorney's office, but also for the surviving spouses or the children of the loved one that passed away. So just the court system, for one, there was a time during COVID that the courts were slowed down. Mm-hmm. So that process I was just talking about of trying to get somebody officially appointed as the personal representative, they need that letters of administration from the judge to get access to the bank accounts. Mm-hmm. But if the court is 2 weeks behind, there's nothing we can do about it. There's no way I can speed that up. So that's one of the frustrations.
We talk a lot about the things that we do and with Helping Seniors of Brevard about preparing, getting ready, getting these things in place early on and not being in the situation where your loved one's passed and now what. So having that loved one do the early preparation to come in and do estate planning and make sure that they've done a will and they've done everything, put it in place, just simplifies, makes things so much more simple than waiting till as myself, just waiting till I pass away and then my kids having to figure it all out. It's all about planning.
Absolutely. And I find a lot with our older clients, they're more traditional. So there may have been one spouse that managed all the finances. Mm-hmm. So, and it's often the male. So the female doesn't always know all of the assets. So I've had multiple surviving spouses that are the women, and they're really left scrambling to figure out what bank accounts were there, what life insurance policies were there, IRAs, annuities, all of the different assets. So it's so much easier for the ones that plan it before. They already get their assets maybe titled into a revocable living trust for both of their benefit, or add their spouse as a beneficiary designation. So it helps those left behind a lot if you do that pre-planning.
Mm-hmm. At what point do you want to avoid probate altogether?
Well, sometimes people still are aware of all of the assets, but they just want to go through the probate process because they can't make a decision maybe on who they would want to put in their will. I would say, I would almost advise you to always want to avoid the probate process if you could. Always do an estate plan, have things in your trust, and that way those left behind can really have an easier time, because everybody's already grieving over the loss of the loved one. So if you have to add in finding assets and who's going to pay for the funeral expenses, that's an area I often see the siblings potentially arguing. Usually some siblings are in a better financial system, others in a worse off one. So I as a probate attorney would say you should always try to avoid probate.
Mm-hmm.
Well, it's kind of tragic. I've seen over the years where a death in a family of the patriarch or the matriarch creates all kinds of problems with the siblings. A loving family ends up becoming a warring family. And is this something then that would help avoid that? Or I'm sure you've seen some incredible situations unfold in your conference room when you've got the families in there, and it becomes either a sitcom or something that you're shaking your head at that you can't believe.
Oh, absolutely. I've seen many families destroyed from the probate process, which you feel so horrible for the person that's passed away, because you know that they're rolling in their grave. That is the last thing they would want. But a lot of reasons I see, one would be if they don't do a will. So pursuant to the law, without a will, the assets are transferred in a way that the loved one would not have wanted. But because they didn't do a will, it has to go that way, and there's nothing we can do about it according to the law. Another huge area that we see is titling of assets prior to the probate process. So oftentimes my clients are from the Northeast. Mom or dad moved down here. One or the other one of them passed away, so only mom or dad was left. So one of the kids moved from the Northeast down here to help out the surviving spouse, mom or dad. At some point, mom or dad has one bank account. They add that one child onto the bank account just to help them manage the checks and their finances. That child has no interest in the account. They didn't add any money to it. But unfortunately, because they titled it as mother and son, maybe upon mom's passing, that's all the sons now. So instead of it going 4 ways like it should to her kids, if that child wants to say, no, it's all mine, it can go that way.
Yeah. I was just going to add, there is a great Helping Seniors television show that we did with Amy Van Fossen on this exact topic. It's titled do you want your kids on your bank account or on your house? And this is exactly what she's explaining. Some of the, even though you have good intentions about why you might want to do something, she's real clear that there's better ways to approach this problem than just, oh, here, let me add this child to the bank account, for a lot of the reasons that you're just talking about. I wanted to ask you a little bit too, because, in the various conversations we've had along the way, I remember sitting with Greg Schwindeman in your office, and we had a talk about guardianship, and it was from a vantage point that we'd never talked about before, which is that somebody comes into the office, now they're in a situation where this loved one is now unable to do things, but there was no provision or no setup ahead of time to be able to manage for that situation, power of attorney and things like that. And so now all of a sudden, Greg has to look at them and say the only option here is guardianship. And kind of what I'm hearing a little bit from what you're telling us today, Katie, is that that's almost a conversation that you sometimes will have to have with somebody, say, well, because we didn't have this plan ahead of time, now the only thing we can do is move through probate. Am I saying that?
Oh, absolutely. So, and it can happen, there's always issues of capacity in the law, and that's an area where attorneys, we have to, meet the individual. I can't allow somebody to sign a will that doesn't have capacity. So unfortunately, with Alzheimer's or dementia or any of these later in life illnesses, I really have to assess my client to ensure they have the capacity to sign these documents. So if it gets too far along, there is nothing that I can do. At that point, I cannot have them execute a will or a power of attorney or any legal documents. So their assets will be distributed according to the law without a will, which is called the intestate law.
Wow. So everything that we keep learning is that thing that they always tell us, the ounce of prevention is worth a pound of cure thing.
Absolutely.
And what I have understood is it makes more sense to sit down, because the amount of money you're talking about, to sit down and put together an overview of what you're trying to accomplish is like peanuts relative to the possible unintended consequences that could happen because you didn't do that.
Right. Even a simple power of attorney for a married couple, one, to each other, can avoid the necessity for a guardianship because your spouse had a catastrophic event but didn't die. And now you don't have anything as a spouse to say that you have the authority to manage his affairs.
Right.
So you're doing a guardianship, and they're very expensive.
So let me ask you this, Amy. We got a lot of stuff we're going to cover today, because we're also going to bring in this whole topic of reverse mortgages and how that fits into the guardianship equation. The probate equation. But if somebody wants to give your office a call and maybe dig a little bit deeper, how do they reach the law office?
Well, our phone number is 321-345-5945. So they could call the law office, and whatever department they're interested in, whether it's estate planning or probate, guardianship, they could VA benefits, they could just speak with the receptionist, let them know, and they would get them in touch with the appropriate attorney or staff member. Yeah,
and I think, too, you guys have a very robust website at amybvanfossen.com. And I remember, too, you guys are pretty well known for doing these seminars where you're giving people a lot of information. And I know pre-COVID, I would see on the events calendar where Amy or one of the other attorneys in the firm would be giving a talk about this, about maybe VA benefits or perhaps estate planning or different things like that. I know we held some of them over at the resource center that over on Beachside, and they were very, very, I guess I would call them vital and beneficial, because they're causing you to think about questions that the normal person walking down the street might not have even thought about, or worse, might have thought they had a solution because they went down to an office supply store, picked up a form, or tried to do their own paperwork. So I wanted to ask you too, but now in COVID world, do you have some of these like online where people can go and take a look?
Absolutely. So we're still having our seminars, which would be another, if you're interested in any of those workshops, just calling the office and setting up to see what times we have available. But we're offering them via Zoom. So I've had multiple seminars where people are just logging in on their computer, and they also would get a free consult with an attorney after attending a seminar. So that's another benefit.
So coming back to the frustration of probate administration, I'm looking at some notes that we wrote down before the show, and it says appointment of personal representative. So again, I guess what we have is a situation where the person has passed away, and now somebody's trying to pick up the pieces and figure out where to go next. So I assume if it was clear, like there was a will or something like that, then you ask the court to recognize that person. First of all, is that right? But then the follow-up question is, what if there is no will? How does that work?
So one of the main purposes of a will is to name your personal representative, and hopefully they named a backup as well in case your personal representative has passed away prior to you. If there's not a will, then there is a statute which states that the surviving spouse has preference of appointment. And then if she or he chooses not to serve, then it would be the majority in interest of the heirs.
Okay.
So pretty much whatever child all the other siblings agree to.
And what if the siblings don't agree, like you guys were talking about just a few minutes ago?
They'd have to, petition the court, and the judge would have to make that determination.
Does that happen a lot?
No, I haven't seen it happen. Usually, there's an agreement. In almost all families, there's usually one very responsible, financially stable individual that takes on the challenge, because being a personal representative is like a full-time job. So everybody already has their own lives, their own families. So they're usually pretty happy when one of their siblings steps up to the plate.
Yeah, no, I hear you. So as we get to the other side of our mid-show break, we're going to cover, we're going to keep on this topic, but we're also going to introduce the part that we were talking about before the show. And I was really fascinated to hear you guys talk about the ramifications of what happens in a reverse mortgage situation as it gets to probate, even to the point that both of you guys as experts were saying there may be some things we need to collaborate on to get the best answers we can. So I'm glad we're going to have this radio show about this today. I just wanted to, I guess we have a minute or so before the break. I want to give you a quick update. Was having a great conversation with Joe Steckler, who is our president and founder of Helping Seniors yesterday. They are working him out. He's getting like 3 hours a day of physical therapy. Wow. Those of you that know, he had knee surgery back over the summer and had some complications with it. But if you know Joe, he's a retired Navy captain. He's a fighter. He's a survivor, and he's on his way back. He's already working on the car raffle. We're going to talk more about that when we get to the other side of the mid-show break. John Harper.
All right, and we will do just that as we continue on this Wednesday, helping seniors of Brevard. Heard every Wednesday afternoon, 12 noon to 1 o'clock, right here on 90.3 FM. We'll check our weather forecast, then get back to more of our conversation, helping seniors of Brevard. 12:33 in the afternoon here on 90.3 FM. As we continue with our Wednesday Helping Seniors of Brevard, let's get back to more of the show. Here's Kerry Fink.
Hey, thank you, John Harper. And we're so excited to be on the radio today, as we are every Wednesday at 12 noon on 90.3 FM, WEJF. And, we also archive all these radio shows, the TV shows, every media thing that we do, the newsletters, everything, all goes to helping seniors of Brevard.org. And it's fascinating because, people often like to search things out by topic. They run into a situation. Sometimes they call us on our senior information helpline. Well, let me go ahead and give you a second to grab a pencil, and I'll give you that number. But Kim Bernard, our education specialist, gets call after call after call and does the best job that she can to make sure that we're connecting folks with the correct resource to advance the situation that whatever they're trying to work their way through. And that phone number is 321-473-7770. 321-473-7770. And again, on the Helping Seniors website, the Helping Seniors of Brevard YouTube channel, or the Helping Seniors of Brevard Facebook page, you can find access to all these great tools. And I was thinking, as we were talking during the mid-show break, our guest today is Katie Jackson Stolz with the law firm of Amy B. Van Fossen, and also Barbara McIntyre with Reverse Mortgage Funding. Hey, guys, welcome back.
Well, thank you.
And our topic is frustrations of probate administration, and we were talking before the break about some of the things that come up as people pass, and then other people are left behind trying to sort out what's next. And during the break, I was asking him, there's a note we had written down here about Creditor Period and a notice of administration period. And you did a great job of kind of like explaining to me what those were. So if you don't mind sharing that, Katie, with our listeners, that would be great.
Of course. So when you do a probate process, assuming that the individual has passed away within the last 2 years, you're required to do a creditor period. So there's a notice of administration as well as a notice to creditors. In Florida, we have a 90-day creditor period where we essentially send the notice to creditors, to any known creditors. The document lets them know if you have a claim, here is the case number. It's in Brevard County, Florida. You can file a claim. This is how you do it. Here's the statute, and here's your time period to do it. Likewise, the notice of administration, it essentially states, this individual has passed away. There is a court case open in Brevard County, Florida. The document is to go to all interested people. So that would be children of the decedent, the spouse of the decedent. It lets them know there's a case, if there's a will, if they want to contest or bring forth any actions, here's the time period to do so.
Okay. And as we started to talk about that, then we got into this discussion about properties and how they transfer. And I guess there's maybe different discussions. There's like if it's a homestead property, if it's like investment property, it could be out-of-state property. And then the case that we really want to focus in on today would be a reverse mortgage property and how all that happens. So I'm not sure where to dive in. You guys are really the experts on it. Just keep it at a level that we can all track.
We'll try our best. So with lenders that hold mortgages on property, you have different types of mortgages. So a person may have a conventional mortgage where they're making principal and interest payments every month, and they have been. And when that person passes away, usually the heirs will continue to, somehow, as they move through this process of working through what happens next, they'll continue to make the payments. So as long as they're continuing to make the payments, the lender really doesn't rush to try to settle the mortgage or claim an interest in the property. That typically happens if on a conventional mortgage where payments are made, if the payments stop and nobody is making those payments any longer, eventually then the lender would start a foreclosure proceeding because they're not being paid. In a reverse mortgage, unique to that mortgage specifically, what calls our mortgage due and payable is when that borrower living in the house no longer lives there. So when the borrower dies, if it's the last borrower on title and they both have passed away, then our mortgage is definitely due and payable. Now, the family, the estate, is given 6 months with 2 90-day extensions if needed. So they're given up to a year to resolve the mortgage without risk of foreclosure, as long as they're working with the lender. But it is a due and payable because the borrower, the condition of having the mortgage was living in the property. So reverse mortgages are unique in that way.
And that is really, it doesn't matter if it's, well, I guess by definition, it would be the homestead property then. Because
yes, it's always the homestead in a reverse.
So let me ask the question, because I think one of the misconceptions that I remember you taught us many years ago, because I think most of us just thought, well, reverse mortgage, the person passes away, that's it for the house. There's nothing left for the kids or anybody downstream.
Right, the bank takes the home. That's what everybody thought.
But that's not.
Never
you've
been
educated us that that's not actually it. It's just
never been true.
How much has been borrowed, and that
right,
goes
because all mortgages are a lien interest. They're not an ownership interest. So there aren't mortgages out there that entitle the bank to own the house. So it's always just a lien interest. So when you pay off a conventional mortgage or you pay off a reverse mortgage, you're just paying back a lien holder.
Right.
So when death occurs, as long as principal and interest payments continue on the conventional mortgage, you can just kind of go along. But on a reverse mortgage, it does create a due and payable event.
So then, Katie, from sort of like your perspective, somebody walks in and says, well, so-and-so just passed away in my family. I'm the son, I'm the daughter. Here's what mom had or dad had, and I don't know, but it looks like they had a reverse mortgage. How do you start to work and figure your way through all of that?
From my experience, usually the lender, whether it's reverse mortgage or the conventional mortgage, if the home was titled just in mom or dad's name and nobody else, and now mom or dad has passed, they won't speak to anybody unless they're a personal representative. So different lenders have their own rules, but the majority that I've spoken with, they want a personal representative appointed before they will speak to the beneficiary.
Barbara, what happens in the case where a person with a reverse mortgage is living in an assisted care facility and they're not physically in the house themselves? How is that handled?
They have left the property, so that triggers that maturity event. So if they were the only person on title and they were the person who had the mortgage, they moved to assisted living, then that reverse mortgage is due and payable. Usually, if someone is moving to assisted living, then they would want to sell their home in order to have assets to pay for the assisted living. So it usually works out perfectly. So you're absolutely right, Katie, that all lenders want to see the representative has a legal interest in the property, because if dealing with the lender is going to require passing title or creating a sale and paying off the mortgage, then the person they're speaking to has to have facilitated that legal ability to do something. And that's where we were talking about how you title your property, particularly in the case of a reverse mortgage, can come into play to more quickly pass property to your heirs. Mm-hmm. There's just a number of ways to do that. So we were talking about the benefit of a revocable trust, or even when a person their only asset is their home, the use of a type of warranty deed that will allow them to pass a property quickly to an heir, so that now, upon death, the heir does have the legal ability to speak to the lender. And you take away all the time for probate. You don't need probate at all. So
when you sit down with somebody at the point that they're consulting with you, maybe they're like, okay, I'm thinking about this. This might be something I want to do. Do you spend some time with them figuring out these kind of questions about where they are on the title and those kind of things?
Absolutely. The first thing I do is look to see how the property is titled. I look to see if there's already a child that's on title as a co-owner. I look to see if they have a life estate that their heirs are already entitled to be part of the transaction, or if they have, and then we get into the weeds a little bit, or if it's an enhanced life estate where they don't need their children to be involved in the transaction, but the property will pass quickly to their heirs upon their death. I always tell them that they need to see an attorney if they don't have a power of attorney in place for themselves, if they don't have a will, that the way to make the reverse mortgage work efficiently upon their death is to establish a clear path to title when they pass away. Mm-hmm. Those are my exact words, because sometimes people get a bad taste in their mouth about a reverse mortgage, because when they get to the end and the parents have passed, they see what happens next is a bit of a nightmare. Mm-hmm. And it doesn't have to be. If a clear path to title was established when they did their mortgage, then it's just like anything. It just flows the way it's supposed to. The kids understand what's going to happen. And, we provide all kinds of documentation about what happens when the loan is due and payable. It's in their closing package when they get their mortgage. So, it's knowledge is power. That's my favorite line.
So in the case of when you're talking with the person that's looking at pulling that together, and you say, hey, listen, you really probably want to take a look at this. So then do you send them, if they don't already have all this together, you're going to say you need to really be talking to an elder law attorney.
Exactly. Call Katie.
Well, how convenient would that be?
Well, I'm telling you.
No,
I always refer to Helping Seniors of Brevard, because I know all of the people involved with helping seniors are strictly there for the benefit of Brevard seniors. And, our seniors are always top of mind. So, yes.
I would, and Katie, I'm probably projecting this onto you, but I would think that you would probably want to see somebody at the point that they're sitting down with Barb to make sure that they've done the correct steps, like you guys are talking
Absolutely.
about, to get that, would you say, clear path to title?
Exactly.
Yeah.
For their heirs to have a clear path to title upon their death. That is just paramount. It's regardless of what kind of mortgage you have, or people that want to leave their children in a good position, because, like we've said before, the saddest time in the world is when you lose your parents.
Yeah.
But when your parents have done their due diligence and made this easier for you, it's just a kind thing. It's just kind, is how I see it.
So again, Katie, I would think you would rather see somebody at the front end of this, because then they're well set up for the back end of all this.
Oh, absolutely. And I love everything Barb said about how she actually brings that to the attention of her applicants, how to get clear path to title. If they do come to see an attorney at that time, it really opens up that bigger conversation about their other assets and how can we as a whole avoid probate and make the transfer of your assets to your beneficiaries easier. So when your children are grieving, or your spouse is grieving, or your loved ones, they don't have to worry about it. You've already taken care of it. And we do see that often, where people some of our best clients, they had to go through probate themselves, and they know what a horrible, how it felt and how it might have torn their family apart. So they really want to pre-plan, because they do not want to see that happen to their own family.
Katie was telling us that just the time it takes when you file those letters for the creditors and administrators, 90 days. You put it out there, you can't do it, you're stuck for months that you can't really go forward.
Yeah, and meanwhile, you've probably got people yelling, hey, we need our money, or stuff
right.
like that's
and
going on.
If everything was tied up, if you didn't have, something arranged, people that really even plan their funeral. They even do those.
Absolutely.
Because that's a kindness too,
Yeah.
It's so...
Doesn't leave somebody guessing. So we still got plenty of time in the show left, but I want to go ahead and get some phone numbers out. So, because I am sure this conversation is sparking people going, wait a minute, I've got some questions that are coming up. Mm-hmm. So Barb McIntyre, how do people reach you at Reverse Mortgage Funding? And just because I know you're very generous with your time.
Absolutely.
You're a great educator, and you're willing to sit down with people and help them understand what their options are and do it the right way.
Even if they already have a reverse mortgage.
Right.
Surprising how many people have one and don't understand. So yes, I love to, as you can tell, I like to talk. I totally love my product, and you can definitely reach me anytime at 321-259-7880. 321-259-7880.
And while we're passing out phone numbers, so Katie, can you share again, if people say, like, this is really causing me, I need to get, here I'm at a year end, getting ready to go into the new year. I want to start the new year the right way. And I think they ought to give you guys a call. But what's the number? How do they get in touch?
Our phone number is 321-345-5945. We also have the website, like you stated. We have a Facebook page and Instagram, and there's information on all of our services and just helpful tips on there as well.
Yeah, and that website is amybvanfossen.com. And you're right. There are some good tools there. And again, as I mentioned before, if you just want some good general information to help you get kind of familiar with some of these topics. I know if you're like me, some of this conversation can be a little bit intimidating if you don't, occasionally you don't understand one of the terms that's being thrown around. And one of the things that Joe, when he formed this organization, he really wanted to help people develop an aging plan, because we always say aging is kind of on the job training. And so the best you can hope to do is learn from those who have been on that road in front of you, and try to learn from anything that might have given them a headache along the way. And that's why this topic we're talking about today, frustrations of probate administration, is so important. So as it comes to this conversation particularly about reverse mortgages or other aspects of probate, what are the things that we can do that help you as an attorney and us as a client avoid those frustrations, Katie?
I would say just being organized. Even if you're a private individual and you don't want to verbally tell anybody what you have a little binder in your house somewhere that has your documents, and just a list of the accounts that you have. So whoever does find that is able to have a map of what to do in their next steps, because the more organized the client is when they come to me, the better I can assist them and the faster we can have the process go.
Now, it's so important. So when we talk about back to the reverse mortgage conversation and the impact of that on probate. So you're saying that there may be ways that simplifies that whole process if you set it up correctly, Barb?
Well, as far as absolutely, as far as the title to the home, there are types of warranty deeds, like we were started to say, that can move the property into the name of your heirs, and it can be multiple people. It can be all four of your children. It's very easy. You just list them as the remaindermen, that upon your death that they're going to inherit the home, and it's just a one or two sheets of paper like a regular warranty deed. It's very simple. What's appropriate to my mortgage, to the reverse mortgage, is that the borrower, the owner of the home, has the right during their lifetime to mortgage, to sell, to encumber the property. They have total rights with whatever they do with the home during their lifetime, but upon their death, their heirs inherit it. And so that clearly passes the property to their heirs, and that makes the process of dealing with the reverse mortgage lender immediately very simple. So it really takes the frustration away from the grieving children.
Katie, in regards to distribution of property to heirs, is it advisable that the person who is doing his or her will take pictures of various items that he or she wants to be distributed so that it goes to the right person?
They can definitely do that. In Florida, we have the ability to attach what's called a separate writing to a will. So you can list on that separate writing without pictures, my pearl earrings are to go to my daughter, Jackson. My painting, my Van Gogh painting, is to go to my cousin so-and-so. And so that's also an option in Florida. And that document, you can actually just do it on a piece of paper yourself. You just need to sign and date it. The people that are a lot more organized, they will take photos and write right on the back of the picture, this goes to whoever. And it definitely makes things easier, because those tangible items are another thing that people sometimes fight over.
Oh, I'm sure. Absolutely, yeah.
Yeah, so if we go back to this general topic of frustration about probate, I guess, clearly the number one recommendation would be sit down and figure this ahead of time so that you know the right thing. And I think another thing that you've taught us during this radio show is that there probably aren't many, if any, situations where probate by itself would be the advisable choice if you'd done some advanced planning. But what are the other things that you suggest that would help minimize the frustration that might come out, in this whole process?
I think having the conversation with your loved ones before you pass is a big way to help them once you've passed, because and put things in writing. So there are also arguments about, no, mom told me she wanted to be cremated and thrown in the lake in Michigan. No, mom told me she wanted to be buried next to dad. So you'll have issues like that come up. So if you have it in your will in writing, it's very clear, and people won't fight over it. So I think a lot of people are in denial that they might be passing soon, or they just don't want to have the conversation. So having those tough conversations before you pass will really make it easier on your children and your loved ones, because once you pass, if they know that they're following your wishes, they're going to feel better about it. If they're arguing over them, they're going to feel worse about it, hold grudges, and it could destroy the family unit.
And this is probably going to be a dumb question, but I would assume that the very process that you guys, as an elder law firm specializing in these kind of things, you've seen all this stuff before. It's probably not much that you haven't seen before. So even if a person were to come in and say, well, I don't really even know where to begin all this, I'm assuming that you would probably be in a pretty good position once you see where everybody, where this person's stuff is, to go, well, kind of based on what we're seeing here, this is maybe the most ideal way to set things up.
Oh, absolutely. And I would definitely advise as well. It's a bit simpler when it's a traditional family, a husband and a wife. There's no other prior marriages, and they just have children together. It's a lot simpler that way. Whether there's a will and they're leaving everything to their children, or there's not a will and you're following the law without a will. Things that get the most complicated is when there are prior marriages and prior children and they don't pre-plan for those things. Those are some of the cases that get the messiest. And those are the clients that I would, or potential clients I would most advise to come in and have an estate plan done so that they can really have their wishes passed on upon their passing.
You know, as you're saying that, again, I come back to this, it was a television show with Amy B. Van Fossen from your law office. It was called, should I put my kids on the bank account or on the house? And of course the answer was no, but it was very interesting how she walked through the explanation of why, even if you had good intentions, it's not the right thing. And she was explaining, and I remember this clearly, she was talking about the fact that even though, son and daughter-in-law may have a great marriage, something could happen at some point. Right. Now you've got to switch there. Or just like what you're talking about, where you have the complication, maybe there was children here and children from the previous marriage. And while you had a plan that things were going to move in a certain way, those things could, if you just left it up to the court, so to speak, could be shifted around in a way you certainly didn't intend.
Mm-hmm.
Absolutely. And that's, oftentimes too, if you can also, it can hurt your ability to apply for public benefits as well if you start adding your children onto accounts and property, because it can be seen as a gift.
Yeah.
But absolutely, oftentimes as well, in that situation I was saying before the break, if one child moves down here from up north to take care of mom or dad, they get added to the account. Once mom or dad passes, they're grieving, maybe they're not thinking straight. Instead of sharing it with their siblings like they know mom or dad wanted, they'll say, you know what, I've been taking care of mom and dad for the last year. I sacrificed, and it's mine. This $200,000, it's mine. So adding children to an account, although it may be easy for you to help write your checks and manage your affairs, it could end up a bad situation down the road.
Yeah, wow. Well, we're really about out of time for the show. I just got enough time to get everybody's phone numbers in here one more time. Bob McIntyre, Reverse Mortgage Funding.
321-259-7880.
And Katie Jackson Stolz.
321-345-5945.
And again, you want to take advantage of this information. It will help you. So we'll see you next week on Helping Seniors Radio.